Good morning.
Good morning, Your Honor.
Good morning.
Let's see. I have a question for the district attorney. I've had a package of your instructions for a while, and then I was given a manila envelope with another set of them. Is that a different set or is that just another copy of the same ones?
Judge, that is a different set. And the reason is that several of the instructions we originally requested have been withdrawn because they're no longer applicable based on certain evidence that came in or didn't come in, and that there are several others that were needed to be added because, again, of the evidence the way it came in the case.
Well, I guess what I'm going to do is, I've spent a considerable amount of time analyzing the instructions given to me by both sides before today. So I'm going to use the set that I've worked with now for quite a while.
Right.
And to the extent that you want to have me take copies out of the new set, you can do that. But there's no way I could start again this morning to figure out what you're doing.
Judge, I don't think you're going to find this to be a problem, because I think on your own you will discover that some of the ones that we requested are not applicable. So I don't think this is going to be a big thing. And I want to let you know that the ones we submitted this morning are ones that have all the his, s and the her, s corrected out of it and the applicable language inserted, so we thought that might be helpful to the court.
That would be helpful.
So I think you'll find those to comport with what the actual instruction should be so it can be read in an intelligent manner.
Okay, and I did get a few new ones from the defense. They're new suggested specials, which I anticipated specials from both sides being submitted.
As I understand it, Your Honor, just so we're clear, we don't have any specials from the prosecution.
Other than what they'd already submitted in their original package, like 222 Penal Code section, which was the last instruction they added.
Okay.
And I think they did during the course of the trial at one point, although I can't remember if. Maybe I did a special myself on the Bashir tape.
We had requested the court to take judicial notice of certain things and you said you would defer those until the time of the instructions.
Right. You'll need to bring my attention to those items. Okay. I have made a list of the instructions, comparing the ones that have been given by both sides, and made some notes on which ones need to be modified, which I think is what you were addressing, Mr. Sneddon, that maybe the modifications have already been given. So if we start at 1.00, I showed that both of you had requested that. And now I see that on the new one from the DA, you don't request that. Is that correct?
No, Your Honor. We do request that apparently the program, the CALJIC program we have, knocked off 1.00 in this list. We have included it as a part of the instructions and it should be given. I don't know why, I just noticed now that it was not at the top of the list. It should have been.
Okay.
But I would think it should be, yes, Your Honor.
I'll give that, then. And then 1.01, I'll give that. Both of you requested that.
I gather, since we're not hearing anything, that the new packet of the district attorney from this morning does not have changes to these so far.
Right. 1.02, and I think this is where you have. There is some selection had to be made at that point, right? That's why I just need to see what it is.
Judge, since there were stipulations, we removed the brackets on 1.02. I think you'll see that in the one we proposed. Other than that, I don't think there's any changes to 1.02.
All right, the brackets are removed as to the party making the objection, is that right?
Your Honor, actually.
I'm making the stipulation, excuse me.
Yes, sir. Where it says, however, if the attorneys have stipulated or agreed, the CALJIC has brackets, and we simply removed that because there were stipulations during the course of this case.
Okay. Do you understand that, Mr. Sanger?
Yes, they had. They left one bracket in their original thing and they've taken it out. So we'll take that. That's fine.
So that's fine. I'll give that. 1.03.
Again, Your Honor, we removed the brackets because we have had witnesses testify in Spanish.
Okay.
And I don't see any brackets in their original version, so I take it it's the same.
That's true. So I'll give that. 1.20. 1.20 is okay. Willfully defined, I'll give that.
Your Honor, you skipped over 1.05. The prosecution withdrew it.
Okay.
We did not. You've already given that at the beginning of this case, but it's such a long case that it might be good to give it again.
We could give 1.05 minus the first two paragraphs.
Yes.
Is that your request?
That would be my request, Your Honor.
Okay. Modify that. Jed, for purposes of preparing these, you're going to take notes and send them over to Carrie?
Yeah.
So the first two paragraphs of 1.05 would be deleted.
Okay.
Then 1.06. It looks like that's a correct statement that should be given. You don't have that in your second group, Mr. Snedden?
No. It seems to be. I mean, I'm not making an excuse, but it seems to be covered by other instructions that are going to be given. If the court recalls, on the conspiracy instruction, you actually even have to read the entire overt acts and indictment again. And with regard to the other offenses, since there's only one defendant in this case, it seemed it would be covered, but we have no problem if the court wants to give it. Seems to me this is more where you have multiple defendants, but there would be no harm in doing it.
I really actually like the idea of, right at the beginning, reminding them of exactly what we're going to be talking about in total, because the rest is all piecemeal. Is there any objection?
None.
Mr. Sanger?
There's no objection to that. I think the bracketed part at the bottom, there are no lessers.
Well, there's a question on that. And do you want to just think for a moment? Is there a lesser included providing intoxicating liquor to a minor? Isn't that a lesser included of the administering an intoxicating agent to assist in the commission of a felony?
It probably is. We'd have to look at the exact elements, but I believe that it would be. However, we're not requesting the lesser.
Is it something that you have any say about? I mean, isn't it mandatory for the court to do that?
I believe.
It's not something that the defendant can waive, is it?
I believe the defendant can waive it. But I believe the defendant has to waive it. And, I could be wrong. But I believe the law right now, it's changed, as Your Honor knows, over a period of time. I believe that if the prosecution requests the lesser, then, that may be what the court is thinking of, that the defense can't waive it. But I'm not conceding that, but just having a discussion about it. I believe that may be true. But I think if both sides waive the lessers, unless the law changed again here, and I'm not positive, but I believe we can waive it, if both sides do.
And is that your position, Mr. Franklin?
I don't have a position on that, Your Honor.
They're waiving.
I think the reality is.
I should have said that. That was a lot simpler, wasn't it?
We'd like to look at that during the break, Your Honor.
I think that has to be resolved. There's too many other issues that are tied to that we have to resolve that after the first break. I mean, I want to know that because we'll have to change this instruction. We'll have to change other instructions. This isn't something that we can decide at the end of the day. It's something we have to decide at the beginning.
Just 1 second. There is a section in CALJIC itself that deals with lessers. It's Appendix C, as the court knows, and it may answer the question right now as to the current state of the law.
Which one? I'm sorry, Your Honor, I didn't hear which one he said. C or
C.
It does appear that the Breverman case, 1998 case.
They can't hear you.
The Breverman case, 1998 case, from this, looks like it may be controlling. It looks like the court would have to make a determination as to whether the evidence supports the giving of a lesser.
And I have looked at all of the charges. And this is the one charge that seemed, to me, that the evidence does support the giving of that lesser.
It does.
Which would then make it sua sponte required instruction, and I don't see anything in there that allows a waiver.
Yeah. Just reading the discussion and refreshing my recollection such as it is on this, it seemed to me that we had an argument at one point that if both sides agree, and there's a stipulation and a waiver on the record by the defendant personally, that the court does not have to give it where there's but, if, because the language was notwithstanding the waiver by one side or the other. There was some language in the case that left the door open, not to mention doors being open to interpretation, that if both sides actually agree and the defendant waives it on the record. But I'll submit it, Unless the court wants to take the next break, and we can take a look at the case itself.
What's your, Mr. Snedden? What's your position? Mr. Franklin doesn't have one, so I'll ask you what yours is.
Well,
You still want to wait a few minutes?
no. I'm convinced that the court needs to give it.
That's what I thought. Okay, so then that language at the bottom of 1.06 would be necessary.
And just for the record, although I would suspect if the prosecution is not joining, our position is fairly weak on this, but for the record, we would object to the giving of an instruction on the lesser.
Okay, now, one of the questions I have, which I think has to be decided, again we have to discuss it early on, because it will come up in other instructions, is in count 6, the crime alleged as an attempt to commit a lewd act upon a child. May I ask what acts you're relying on for that? Off-the-record discussion between the court and court research attorney Jed Beebe.
Does the court want me to respond to that, Your Honor?
Yeah, just a second. If you'll wait just a second. Okay, yes.
Specifically, the testimony from Gavin Arvizo that the defendant reached over and grabbed his hand and moved his hand towards Mr. Jackson's crotch area, and that the boy then took his hand away and said he didn't want to do that. I also believe that there's some testimony that at that point Jackson said something to the effect that it was natural and okay, but the boy didn't want to do it.
All right, thank you. Additionally, in 1.06, I think we should add the language, in count 1, the crime alleged is conspiracy. And then say, instead of moving right to the date, to commit the crimes of extortion, false imprisonment or child abduction, to make the statement to the jury clear at this point. And then I'd like to add at the end of the instruction, after the last paragraph, in counts 7 to 10, namely, administering an intoxicating agent to assist in the commission of a felony, the lesser crime is furnishing alcohol to a minor.
Your Honor, does the court have in mind the furnishing aspect being the violation of 272, contributing, or the specific B&P code section?
The specific B&P code section.
Okay, I just wanted to know. Thank you.
And that would be 16.010. We would modify later to, when we get to the specific offenses, to have that. Use paragraph 2 of that. Furnishing liquor to a person under 21. The second paragraph. Every person who unlawfully sells, furnishes, gives or causes to be sold, furnished or given away any alcoholic beverage to any person under the age of 21 is guilty of a violation of Business and Professions Code section 25658. Subdivision A misdemeanor. And then it goes on. In order to prove this crime, each of the following elements must be proved. 1. The defendant, Michael Jackson, furnished, gave or caused to be furnished or given away an alcoholic beverage to Gavin Arvizo. And 2. Gavin Arvizo was under the age of 21.
At the end of 1.06, Your Honor?
No, I'm going to put that at 1.06.
Oh.
I'm going to put it back where we have a discussion of the crimes.
I agree with that. That's not what I meant. I'm sorry. I was referring the court's attention to the end of 1.06. It says, you indicated, the lesser crime is furnishing alcohol to a minor, and I think that should say, a misdemeanor. Is that correct?
It should. You can say that if you want.
Well, it says that.
We will say that.
It says, a felony, elsewhere, so I think we should say that.
Yes, I think you're right. Okay.
I think 1.12 was requested by both sides and was withdrawn by both sides. If it wasn't by us, it is now.
1. What?
12.
1.12.
Oh, yeah.
Yes.
Now, in that regard, if the court is going to read the indictment at some point.
I don't think I need to read the indictment.
I don't think you do. I heard Mr. Snedden say that.
No, I didn't say that. I said that there's a CALJIC instruction which requires you to read the conspiracy charges and the overt acts in the 1600 series.
Which you've already prepared.
I have.
And the only problem with it, in the old package, I haven't seen the new package, was that the DOE names were used.
The new package does, too.
So we want that instruction with the names in it.
We can modify that.
We've used their names throughout the trial.
We'll modify that for the court.
Yes. But will you modify it quickly?
Well, how quickly would you like it? By noon?
Yes.
You'll have it.
Thanks. The reason I want to do this is, I don't know if I told you this or not, so I'll tell you. I intend to give each of the 20 jurors a full package of the instructions to read as I read them to them. So I will have those prepared. So I have to have a full package today so that I can have those prepared. You know, usually we have overnight to clean up any things like this. But we don't in this case.
Are they going to be allowed to take their packet in with them to deliberate?
Yes.
Okay.
That's the purpose of giving it to them.
That's fine.
Alright, if we're keeping track, that was my concern, that the name, we don't have does showing up in the instructions anyplace.
That's my intent here.
With that, we withdraw the 1.12.
Okay. 1.12 has been withdrawn by both sides. You know, it's break time. And we have people in the audience that have been sitting even though we've been not sitting here. So I will take the break. That will give you a chance to catch up, counsel, on those items.
I guess we're ready to begin, but we're not going to have the benefit of Mr. Franklin's opinion. A little humor, sorry.
I appreciated it. It didn't call for a belly laugh.
No, it wasn't a real knee slapper, but I appreciate the smile.
1.21.
I think you passed 1.20 without saying you're giving it, but I believe it should be given.
Well, let's see. You're right. 1.20. Willfully, I had marked that off as giving it. 1.21 I will give. That's knowingly. And 1.22.
That's malice. And malice is used in false imprisonment, which is CALJIC 9.72.
That's child abduction.
I'm sorry, child abduction.
Your Honor, it's defined in 9.72 in the sections under child abduction. Maliciously is defined in that instruction.
So we don't need
that, this would be a repetition.
Okay.
If it's not used in any other instruction, and I couldn't find it going through here quickly, then we'll submit it.
Alright, so I'm not going to give 1.22, because it is in another instruction. 1.23, consent, I'll give that one. 1.25, that defines a minor.
I think we asked that, and we withdrew that. That's one of the ones we withdrew because the age limitation is actually 14 in this case.
Well, the age limitation for alcohol is 21, so you've got 3 different ages.
Yeah, for the lesser included.
Well, that's defined, though. In the B&P it says 21.
Under that code section?
I believe it does.
Let me see.
It was 16.010.
Yes, it does say 21.
Yeah, I think that's sufficient, don't you? The furnishing. Do you have that in front of you, Mr. Sanger?
Yeah. 16.010, there's no question that's covered. I'm just thinking, is there any other place where minor is used in this case, and I don't think there is, because I think the other is under the age of 14. So we would agree to withdraw it based on that.
Okay. The next one is direct and circumstantial evidence, 2.00. I'll give that. The next one is 2.01. Sufficiency of circumstantial evidence, I'll give that. The next one is sufficiency of circumstantial evidence to prove specific intent or mental state, I'll give that.
I believe, Your Honor, in the ones that we submitted, that the bracketed information is filled in and/or brackets taken off where appropriate. I just wanted to direct the court's attention to that.
Okay, thank you.
I think that's the same. I think that was done in the original one.
Yes, I think so. But that's good then.
Wait a second. There is another change here. It's modified. Can we have just 1 second, please?
Yes.
I can just indicate to the court, with regard to the originals that we submitted, those were done by Mr. Nicola. But the ones that we submitted this morning were done by Mr. Franklin and I over the weekend, So I have a great deal more confidence in the fact they may be the same in some cases, but
Looks okay.
yeah.
But you're looking at something that I don't see, mister.
There is a difference, and it may not be a big difference, but it always worries me when there's a modification and there's no indication it's modified. The original one just says.
Which one are we dealing with, counsel?
2.20. The first one says, you may not find the defendant guilty of the crimes charged unless the proved circumstances are not only. And then it says, in the second version, guilty of any of the crimes charged in the indictment unless the proved circumstances. Which just causes me to wonder why we have different language. And I don't think it's necessary to say, indictment. Crimes charged is adequate. An indictment is not evidence of a crime.
That's fine. Whatever. It doesn't make any difference.
So we'll take out, in the indictment, and just leave, charged crimes.
If you have your original one, I think that's.
We can use that one.
You can use that one.
No change is necessary, Tracy, because we're using.
2.02 has that language there for the lesser included. But I believe the lesser includeds in this case are general intent crimes, or a general intent crime.
It is a general intent crime.
So I just wanted to bring that to the court's attention.
Okay, all right. 2.03 as consciousness of guilt, falsehood.
We originally requested that at the beginning of the trial.
It is requested by both sides.
But I would withdraw our request and object to it.
Okay, what evidence are you relying on?
Your Honor, I'm specifically relying on that portion of the Bashir video in which the defendant was confronted with the statement about a 40-year-old man sleeping with children, and said it's not sexual, and then went on to portray the incidences being those of where they eat cookies and drink milk, and things like that. And I think that those are fabrications, which I think, if the jury finds those to be not true statements, can be used to reflect his consciousness of guilt.
The only problem is that the crimes charged in this case are alleged to have occurred after that video. That video was done in 2002, the fall of 2002, and the crimes alleged here are alleged to have occurred in February and March of 2003. So it could not be a false statement regarding the crimes for which he is now being tried, which is the language of this.
I don't think there's any requirement that it be during the time frame of the charges. It can be a statement that's made before that reflects on the charges that are currently pending.
It says, actually, deliberately misleading statement concerning the charge for which he is now being tried. So he can't be making a misleading statement about a crime he hasn't committed. I mean, hold him to that, it doesn't seem to me. I think Mr. Sanger is right. Is there any other evidence that you can think of that you?
No, that's what we had in mind.
All right, I'll reject that, as requested by the defense. It's rejected.
And for some reason, 2.04 was in our packet early on. And we'd withdraw the request for that and also object to it.
It can be withdrawn, Your Honor. 2.04.
2.04 is withdrawn. 2.05.
The same with 2.05.
Same.
2.05 is withdrawn.
And 2.06.
2.06. Let's see. 2.05, 2.04. That was withdrawn. Is efforts by a defendant to fabricate evidence. And 2.05 is efforts other than by defendant to fabricate evidence. And those have both been withdrawn. 2.06 efforts to suppress evidence.
I think I said this, but we also withdraw our original request and object.
Do you have any evidence you're relying on for that, Mr. Snedden?
No, you can withdraw that, Your Honor.
Okay. 2.06 is withdrawn. 2.09. Evidence limited as to purpose, that should be given. I'll give that.
We obviously have specials that I take it the court will come to at the end.
Yes, I was just thinking. Should there be something in 2.09 that says, you will be instructed further on that?
Well, I was thinking the special.
On one part we did not instruct them at the time, the takeouts. I am going to give a limiting instruction on that, but they didn't receive it at the time.
Oh, I see. You're saying take the words out, at the time.
Yeah.
Well, I would suggest you leave that in, and then follow this with the special instructions regarding the various items. I don't know whether the court will entertain all of our requests, but following this with the specials relating to the various specific items. And when you introduce the outtake evidence, you can say at the time we did not give a particular limiting instruction, however, this is also subject. So I think you should alert them.
I think you're right, because there was, all right. That's fine. And you're suggesting that we put the limiting instructions right after this instruction.
Yes, sir.
Well, I'll tell you, I'm willing to do that as a placement, but I think I would like to put off the discussion of those until later, because it's going to be a little more intense discussion, but
we'll try not to disappoint you at the given time.
Judge, can I point out that there is still some other limiting instructions that you give that are involving 1101 evidence that there are specific instructions on, so you won't be able to line up all of those limiting instructions under this one.
Yeah, that's why I want to look at the whole
package before we get there.
Yeah, to where it all fits best. I mean, I kind of like the idea of following the general, but we'll see how it fits.
All right.
This is that change, Mr. Franklin, in the overt instruction?
Yes, Your Honor.
Thank you.
The wonders of global search made it faster.
Thank you. Mr. Sanger made a joke about you in your absence, but I'm not going to take the time to explain it to you.
I'll sweat it out of him outside.
Yes.
Thank you, Your Honor.
2.11. Production of all available evidence not required, I'll give that. 2.11.5. I'll give that. That's unjoined perpetrators of the same crime.
Yeah. Just for the, Your Honor already ruled, so I'm not arguing, but just, we would intend to withdraw our request for that and object it.
All right. 2.13. Prior consistent or inconsistent statements as evidence, I'll give that. 2.20. The believability of witnesses. It looks like you have removed the conviction of a felony. We don't have any convictions of a felony, do we?
No.
And did you take anything else out? Character evidence. That's out, right?
Correct. I believe we took out the.
Yes, you did. I'm just checking the other one prior. Okay.
Well, but they also took out past criminal conduct of a witness amounting to a misdemeanor, and whether the witness is testifying under a grant of immunity.
Right.
I think both of those should be in.
Which is that, Your Honor?
Past criminal conduct of a witness amounting to a misdemeanor, and whether the witness is testifying under a grant of immunity.
What misdemeanor is that?
Possibly welfare fraud.
Actually, the law's a bit of an anomaly, because it says, prior conviction of a felony, and then you don't have to have, or you can't just use a conviction of a misdemeanor.
You have to have the facts.
You have to have the facts. However, if you have the facts of a felony, that also would count, where you don't have a conviction for a felony, but you have the facts. So it really should say, past criminal conduct of a witness, period. We don't have convictions of a felony, but we have criminal conduct that amounts to a felony. And possibly to both. Possibly a felony and a misdemeanor.
I'm not sure that's correct. The rule for impeachment with misdemeanors is that you have to impeach by the actual conduct. And with a felony you may impeach by a conviction.
I agree with that, but the obverse of that is not necessarily true. In other words, the fact that you don't have a conviction for a felony does not preclude you from showing felony conduct to show moral turpitude and lack of truthfulness. So the fact that perjury, for instance, is a straight felony, it's not a wobbler, you could only introduce, if the opposite were true, you could only introduce evidence of a conviction for perjury, but you couldn't introduce evidence of underlying conduct, where you could introduce evidence of welfare fraud because that could be either a misdemeanor or a felony, so it wouldn't make any sense. I mean, in other words, I think the rule is that if it's a felony, a conviction is sufficient. If it's a misdemeanor, a conviction is not sufficient. You have to show the conduct. But that doesn't mean that you can't show the conduct of a felony. The instruction is worded that way simply because that's usually the case, I think, that you have.
I'm going to use the instruction as worded and add, the past criminal conduct of a witness amounting to a misdemeanor, and the whether the witness testifying is under a grant of immunity. Do you have that, Tracy? And 2.21.1. Discrepancies in testimony. All give that. 2.21.2. All give that. That's a witness willfully false in their testimony. 2.22. Weighing conflicting testimony. All give that. 2.23. Believability of a witness. Conviction of a felony, that's withdrawn.
I don't think we have any evidence of that.
Is either side requesting that?
I don't believe there's any evidence of that. Actual conviction of a felony.
2.23.1. Believability of a witness. Commission of a misdemeanor. The question there would be whose name goes in there, or names. Evidence has been introduced for the purpose of showing that a witness. Do you want to leave the names out and just argue it?
That's what I think ought to be done.
Well, there's Janet Arvizo and Rudy Prevencio.
Rudy Prevencio?
Manufacturing evidence, false evidence.
What?
And I'm still troubled by this felony, that you can.
Well, let's just move on. Be troubled elsewhere.
It has to do with this instruction, though, and the prior instruction as well.
Let's just deal with the question at hand, please.
I think it should be left blank and argued.
I suppose, because there's more than those two witnesses that could arguably fall into that category. Cindy Montgomery and, so I'll submit it.
It seems better to do it that way, I think, and leave each side to whatever crimes they think have been shown. Is there any, on this issue that you're worrying about, Mr. Sanger, is there anything in the supplements? I mean, these are instructions that have been used for years. Is there anything in the supplements that shows that the language of the CALJIC official instructions shouldn't be followed? I'll come back to it if you want.
Yes, if I could. We'll try to.
Some authority would help.
At a break, see if we can. I was just looking at the use note to see if. It doesn't say to the contrary either, which surprises me, if there's a rule to the contrary. It doesn't say only a felony conviction may be used. It talks about the fact that there's a conviction is adequate proof, and that shows there's moral turpitude, and that's the basis for impeachment. So we'll see if we can take a look on the break at that.
Yeah, I thought that to some extent. Well, do you think we should change 2.23.1 to say, evidence has been introduced for the purpose of showing that a witness, or to show, evidence has been introduced for the purpose of showing witnesses have engaged in past criminal conduct?
Period. That would be my request.
It's changing it, though, from a to witnesses.
Yes.
Is that okay?
That would be correct, yes.
Well, I would prefer that you put witness and then bracket es paren, so that the court doesn't appear to be editorializing that there really are, because this is a jury decision. By putting more in, it's an indication that there is some lack of discretion in this area, and, quite frankly, it is up to the jury to make that decision. Or to put witness or witnesses. But I think to say witnesses tends to imply that there has been some misconduct done, and I don't think that's really, I think that infringes upon the jury's fact-finding process.
There's definitely more than one witness. I mean, I said Rudy Prevencio and I got an argument on that, but
the rest of the instruction talks about a witness.
It would have to be modified throughout, I think.
The to,
Do you have an opinion on this, Mr. Franklin?
Change the to, where it appears. The third sentence, the fact that a witness engaged in. Other than that, with respect to policy decisions, I defer to my senior lead counsel.
I'm not sure where you're saying change, the to,
The second sentence commences, the fact that the witness engaged in.
Oh.
I'd suggest we change the to keep it sort of noncommittal. And I think there's merit to the notion of witness or witnesses.
Witness or witnesses. Is that okay, Mr. Sanger?
yes, Your Honor.
Then I think I'll just leave the alone.
Your Honor, are we going to leave in amounting to a misdemeanor or strike that?
No, that stays in.
Right now it's staying in.
Very well.
And I'm allowing Mr. Sanger to show me a reason to go along with his approach, which would be just to put in a crime, as opposed to a misdemeanor. What's your position on that?
I think if you either specify if you specify a misdemeanor, then you have to define what crimes are misdemeanors. The jury won't know, so there may be some merit to leaving out either specification of a misdemeanor or felony and leave it just crimes. Although it could be argued, of course, by either side as to what crime is a misdemeanor.
So neither side is advocating that we just follow the misdemeanor language then, is that correct?
That's correct.
In that case, we'll follow the crime language. Has engaged in criminal conduct. That's where that would stop, right? On 2.23.1?
Yes. And then, depending on which version you have, 3 or 4 lines down says, amounting to a misdemeanor, should be left out.
Yeah, we cross out, amounting to a misdemeanor, and then again that repeats itself. And then the heading on this instruction should be changed to commission of a crime, right?
Yes. Would it be appropriate to then revisit 2.20 and take amounting to a misdemeanor out of that?
Yes. Okay. And that's where it would say, past criminal conduct by a witness amounting to, that's all. Just past criminal conduct of a witness, huh?
Yes. Period.
Period. Okay. Okay. 2.24. Believability of a witness. What character testimony has been introduced?
I don't think there is, and we would withdraw the request and object to it.
That's fine.
Okay. It's withdrawn by both sides. 2.24. 2.25. Refusal of witness to testify. When a witness refuses to testify to any matter based on the privilege against self-incrimination.
We've submitted a special instruction that tries to grapple with the situation I think we're in here. I don't think 2.25 adequately addresses it. And I know the court ruled otherwise previously and gave an instruction, but the more I've thought about it, the more it seemed that we have the right of confrontation issue when it's a prosecution witness and that should be acknowledged. So I wonder if the court would want to hold this, tab it or something, until we get to the specials.
Okay.
And, actually, the same would go for 2.26. Just hold that, too, because I think there's a special that tries to grapple with all of those.
Neither of those were in the original packages, so I'll hold ruling on 2.25 and 2.26 until we look at the specials at the same time. 2.27. I'll give that. That's the sufficiency of the testimony of one witness. 2.40. Traits of character of defendant.
Excuse me 1 second. Well, there was a 2.29, but I take it that was withdrawn. That was a witness in custody, so, I'm sorry.
I don't have that.
I had a note that the prosecution asked for it. It doesn't matter. If the court doesn't have it, we don't want it, nobody wants it.
Okay. 2.40. I don't think that the.
Your Honor, are we on 2.29?
Well, yes.
Yeah. I think in light of the court's ruling that we couldn't ask any have you heard questions, that this instruction should not be given.
2.29?
2.40.
Yes, I'm sorry. And we're on 2.29 now?
There is no 2.29. I don't have one.
That's a mistake.
Okay. 2.40, which is the traits of character of defendant. So you're right. You're not asking for this. Nobody's asking for 2.40 at this point.
All right.
I think we asked for it, but I think the court ruled that there was not character evidence during the course of the trial.
Yes, which is exactly what you wanted me to rule.
Right. Except for the 1108, which was not character, but it was.
Right.
So I think in light of that, we'd have to withdraw it.
Okay. Both sides withdraw 2.40.
And 2.42 would go as well.
Yes, that's cross-examination of a character witness, so that's gone also. Do you agree, Mr. Snedden?
Yes, that would have been one of the ones we would have withdrawn, Your Honor.
Okay. 2.50. Evidence of other crimes.
We have 2 versions from the prosecution. We got the earlier one, and the more recent one, which is the one we have this morning. I haven't had a chance to compare it and see which brackets were eliminated.
We'll eliminate the he, she on line 5.
Well, that would be a good point right there.
This is evidence that the defendant committed other crimes.
Right.
so you're going to submit a new one with he in it.
Yes.
Just going to take out the word she.
It's doing this on the fly. It's a little hard to tell which brackets have been taken out here, so.
I know.
I see in the new one there's, inexplicably, the word certain shows up at the beginning of the instruction. I suppose it doesn't hurt anything, but that causes me to have concern about the rest of the instruction. I have some observations, if the court is ready.
Yes. Just a moment. Did you want to say something? Off-the-record discussion between the court and court research attorney Jed Beebe.
Which one, Bob?
We're on 2.50. At least I am. I think the court is.
Yes.
I have objections to the new version, and I think the new version eliminated some of what was in the old version that clearly does not apply, so I think we could work with the new version, if that's all right with the court.
Okay.
We're already eliminating the word she up there in the second paragraph. I don't know why the word certain is there. I don't know why that really matters, but that's not part of the instruction at the very beginning.
Okay. We'll take out certain.
Now, I have really two objections to this. After the words counts 2 through 10, the bracketed material, or a clear connection between the other offenses and the one of which the defendant is accused, so that it may be inferred that if defendant committed the other offenses, defendant also committed the crimes charged in this case, which is 1101b. This is an 1101b instruction, and under the facts of this case, that sounds like propensity, which is not what 1101b was designed to do. And I take it there's an 1108 as a separate instruction. The other thing, and I'll just defer to counsel to comment on whatever, but just let me indicate this instruction apparently is related to the alleged sex offenses. It's not related to the conspiracy. There is no conspiracy with regard to counts 2 through 10. So the two paragraphs at the bottom of page 1 that pertain to part of a larger continuing plan, scheme or conspiracy, and existence of conspiracy, that should be eliminated. That would not apply to the 1101b evidence.
I disagree with both those comments. But, first of all, the comment above is the direct language taken from the 2.50, which was bracketed, and it does refer to the inferences which the jury is allowed to draw with regard to this type of evidence. And secondly, there is evidence before the court, before the jury, that involves 1108 type of conduct on the issue of the conspiracy. So it seems to me that this instruction applies not only to the events and testimony directed at the 1101, but also directed to the conspiracy.
May I just have a moment, Your Honor, please?
Judge, just to make it clear with regard to the 1101b, on the sexual part, this is a situation where the jury is allowed to draw inferences from the conduct involved in that evidence for certain limited purposes under 1101, and then those same acts of conduct are allowed to be expanded on in 1108. But that's not to mean that the inferences that are traditional 1101 types of things for modus operandi, scheme, motive and intent are not, that those other offenses, just because they're allowed on the grounds of 1108, are not useful under 1101 for the purposes that 1101 authorizes. I think that's why that language should be kept in.
But I thought the 1101 evidence was limited to the method, the characteristic method. Isn't that why we introduced that?
No, I think in our moving papers we actually delineated 5 separate reasons why it was admissible under 1108, 1101. And each one of these are reasons that we set forth, along with the factual recitation as to why they would be admissible under the traditional 1101 approach.
Well, the way I see it, there's a separate instruction and then we requested a special on 1108. And I understand this is a 2005 revision, and that doesn't mean that the commission that proposes these instructions got it right. In 2.50, they basically talk about common plan or scheme, intent, motive, knowledge, and those are the issues for 1101b. And that's what 2.50 should address. They throw in a sentence at the end of the third full paragraph there, or a portion of the sentence, right after the word 10. It says, or a clear connection between the offenses so that it may be inferred that if a defendant committed the other offenses, the defendant also committed the crimes charged in this case. That's clearly 1108. That's clearly not 1101. There's no reason to put 1108 language in the 1101b instruction. So I think that should be taken out. And the use note also says if you have 1108, you should be using 2.50.01. And once again, The conspiracy is. The existence of a conspiracy has nothing to do with this prior sexual acts, so that should go out. And I think, if you take that last sentence out after the counts 2 through 10, starting with, or the portion of the sentence starting with, or a clear connection, to the end of the paragraph, if you take that out, then it stands on its own as an 1101b instruction. And then you go to 2.50.01, and that covers the 1108. So to the extent it's not coterminous, I think some of the evidence was 1101b, and some of it was 1108.
Judge, I think that counsel's making two mistakes. 1. I think that the revisions to 2.50 are the insertion of the gang enhancement ones, which were previously not in there. I don't think it changes the basic language of the instruction 2.50. And I think what counsel's preoccupied with is the fact that 1101b does not have to be used only in sexual assault cases. It can be used in burglaries. It can be used in robberies. It can be used in murders. It can be used in virtually any type of a crime. And in this particular case, I think we have evidence that not only relates to issues involved in the molestation of Gavin Arvizo, but also to the conspiracy. And particularly motive evidence. And some of the other acts are acts that are alleged in the overt acts from which the jury is entitled to draw inferences.
Well, now, if Mr. Snedden is now saying that 2.50 is just a straight 1101b instruction, then that's all the more reason that you would have to take out that 1108 language, because if he's claiming that it pertains to all of the counts, then it should just be a generic 1101b instruction.
No, that's.
This is how I'm going to give the instruction, then. Do you want to?
Yeah.
Get your materials? Evidence. I'm not going to use the word certain. Evidence has been introduced for the purpose of showing that the defendant committed crimes other than that for which he is on trial. So that sentence has one change, right? And then the next one. Except as you will otherwise be instructed. This evidence, if believed, may be considered by you only for the limited purpose of determining if it tends to show, the next paragraph, a characteristic method, plan or scheme in the commission of criminal acts similar to the method, plan or scheme used in the commission of the offense in this case, which would further tend to show the existence of the intent which is a necessary element of the crime charged. Then the rest of that paragraph goes out. Next paragraph. The existence of the intent which is a necessary element of the crime charged. The next paragraph I will use would be, a motive for the commission of the crime charged. And the next paragraph I would use would be, for the limited purpose for which you may consider such evidence, you must weigh it in the same manner as you do all other evidence in this case. Okay. 2.50.1. 2.50.01. Evidence of other sexual offenses. Evidence Code 1108. Is there any reason, going back to 2.50 for a minute, is there any reason that the heading on that shouldn't at least cite Penal Code Section 1101?
Evidence Code Section 1101?
Excuse me, yeah.
That would make sense.
So would you add that, Tracy? Evidence Code. Just like the next. The way I picked that up is the next one, 2.50.01, cites Evidence Code 1108. And I think, the reason I think that's important is that, to some extent, my instructions to the jurors might have used the numbers 1101 and 1108. I can't remember. To the extent that it does, that would be clarifying help, right?
I don't think it hurts.
Excuse me?
I say, I don't think it hurts.
Okay.
I do have a question about the interrelation between 2.50 and 2.50.01.
Yes.
Your Honor excluded the portion, the traditional portion of 1101b, which is that the evidence cannot be considered to prove that a defendant is a person of bad character or that he has a disposition to commit crimes. Now, I understand that the reason the court did that, I suppose, is that 2.50.01 is going to, say, but you can consider the disposition to commit crimes. However, there is 1101b, evidence that wasn't 1108, so you're not making that distinction. And in case we have anybody who's got an advanced degree in philosophy, they might pick up on that at some point in the instruction. Would it be possible to say at the end, you're not permitted to consider such evidence for any other purpose, and except for the evidence referred to in the next instruction, You may not consider this evidence to prove the defendant is a bad person, is a person of bad character, or that he has a disposition to commit crimes.
Well, I think there is. The sentence in the second paragraph states that it may be considered only by you, or may be considered by you only for the limited purpose of determining if it tends to show. So it tells exactly what the limitations are.
I suppose. I realize 1108 turned the law on its head here, but one of the things that jurors were always warned of in 1101b was that very delicate matter that they're not supposed to consider it for proof of the fact that the person is of bad character or has a disposition. And to the extent there's 1101b, that's not 1108, we're not giving them that admonition.
I think it's clearer if the one instruction, 2.50, tells them it can only be considered for certain purposes, and the next instruction tells them that they can consider it for a disposition. I think it's more confusing to do it the way you're suggesting. Okay. 2.50.01.
We once again have a new one, which is fine. It removes some brackets.
We just took out the ones that didn't apply in this case, which were the
Right. So you left.
force and violence.
You left in A and put B, C, D, E and F, which I think is appropriate, and then you took out she in the next paragraph.
We do have a special on 1108, but I don't think it's going to impact this.
Okay.
So much. And the only objection I don't want to be too picky here, but since any of the following is one.
Is only one.
It should just say, sexual offense means a crime under the laws of the state or of the United States that involves. And then just take out any of the following, any conduct made criminal by.
Striking, any of.
Strike, any of the following, and then it will just read, involves any conduct made criminal by.
Okay. You stop at the United States, is that right?
No. You just say, that involves, and it's just one sentence. Sexual offense means a crime under the laws of the state or of the United States that involves any conduct made criminal by Penal Code Section 288.
All right, and just keep the sentence running.
Yeah, and actually, as I think about it, I mean, I understand there could be conduct outside the state.
Yeah.
But there's no definition of the laws of other states or the United States, so how would a jury know if something violated a federal law or a state law of another state?
Because it has to involve conduct made criminal by Penal Code Section 288. I mean, that's what the real subject matter is.
That's right. Sexual offense means a crime that involves conduct made criminal by. It's not a big thing. It's just a thing.
Okay, so I do think I'll accept your change there and take out the words, any of the following, and the second paragraph at the end, and go straight. Conduct becomes part of the sentence. Any conduct, okay? And the next one is 2.50.1. Evidence of the other crimes must be proved by a preponderance of the evidence, all give that. And then 2.50, 2.50.2. Definition of preponderance of the evidence, all give that.
Yes. So 2.50.1 and 2.50.
2.
2. Excuse me 1 second. Okay. So on 2.50.1, we have proposed a special jury instruction number 4 that I think would basically be a suggestion to modify 2.50.1 with some or all of the language of that. Could we come back to that, or?
Yes. The next one's 2.51. 2.51, motive. All give that. The next one is 2.60, defendant not testifying. No inference of guilt, all give that. 2.61, relying on the state of the evidence, defendant may. All give that. 2.61.
I think 2.70 is withdrawn by both parties. Put it this way. I believe it was withdrawn by the people in their latest set, and we would also withdraw any request for it.
Okay, and that leaves 2.71, admission defined.
Yes, and the people's latest version has the bracketed gender issues resolved.
That's okay. I'll give that. 2.71.5, adoptive admission.
We would withdraw. We would withdraw any request for that and object to that being given.
This will pretty much rise and fall on the basis of your previous decision as to the failure to respond to the accusation on the program, so that's the theory we had. So I would guess that this would be one that you would refuse. We're not withdrawing it, but I think, to be consistent, I think that I need to point out that the court will probably refuse it.
Yes, that's correct. I will refuse it. Then 2.71.7.
And we would, at the beginning of the trial, we submitted a bunch of these, obviously not knowing exactly what was going to happen, but this is one we would withdraw and object to it being given.
And it seems to me this is one that specifically applies, because it says it's a pre-offense statement. And we're talking about the admissions.
But this is designed, I'm not looking at the use notes, but I will. I mean, this is designed for a situation where somebody's talking about, I'm trying to rob the bank, or, I got a gun in case I want to rob a bank, something like that. It doesn't add anything to the.
What did you have in mind?
Hearsay statements about sleeping with teenage boys.
So you've listed. Evidence has been received from which you may find that an oral statement of intent, plan, motive or design. You used all of the words in the instruction. What words were you thinking of?
Well, I think all four of them apply. But that's his intention, that he plans to do that, and it's a motive for the crime in this case, and he has a design on young teenage boys.
That's not the way the word's used. That was clever, though.
It's not what?
You know, it's actually interesting, because 2.71 may not even apply. However, 2.71.7, basically I think what the prosecution is saying is that there's statements that were made that the admissions, under 2.71, would be statements that were made that would be admissions of something that might pertain to the 1108 evidence. It's not admissions as to the future conduct. And 2.71.7 I believe pertains to the kind of pre-offense statements that I referred to, like, I'm going to go out and buy the gun because I might want to rob a bank someday, and then the person robs a bank, and then you say, well, he said he was going to do that.
And our contention is that these statements indicate a predisposition and his intention to continue in this kind of conduct from which the jury can draw a reasonable inference that this conduct occurred with regard to Gavin Arvizo.
Well, then, so that's 1108.
No, it's not 1108. It's an admission. It's an admission on his part. It's his statement. 1108 is conduct that was viewed with regard to other individuals.
Well, I don't mean to get involved in a direct argument with Mr. Snedden, but addressing the court, the predisposition, the word predisposition, is evidence pertaining to predisposition is inadmissible unless it comes in under 1108. So this can only be talking about 1108, in which case it's redundant. It doesn't make any sense the way it's worded. 2.71 would be the admission that would pertain to 1108. It's something that was said after the fact that the prosecution wants to argue bears on 1108 events having occurred. 2.71.7, there is no, despite the creative use of the word design, there is no predisposition issue under 2.71.7. If you say somebody has, you know, we're talking about robbing a bank. I suppose they're talking about robbing a bank, it's not a predisposition. It would go to intent or something. So I think for purposes of argument, I mean, nobody's going to understand this unless it's argued by the lawyers. So for purpose of argument, 2.71 gives the prosecution the opportunity to argue that things that were said on the tape, and the only statements that came in by Mr. Jackson are pre-offense statements. So the things said on the tape they could argue were an admission of some sort that pertains in some way to the 1108 evidence.
That is not
1108 evidence.
what we're saying.
Excuse me 1 second. 1108 evidence, then, is offered for the purpose of showing there's some predisposition, which are propensity. But 2.71.7 doesn't advance the ball for anybody.
This requires, in your mind, it requires some statement that shows at that time he's contemplating a crime of some sort.
That he's
So his statements,
subsequently charged with.
that he allows young boys to sleep in his room doesn't show a crime. That's what you're saying?
Well, that's correct. But it doesn't show the intent, plan, motive or design. He's talking historically at that time. If you remember, the statements that were selected were statements with regard to Gavin Arvizo that occurred prior to 2003, and then also a remark. We have it here someplace, but a remark to the effect that he has allowed other children to sleep in his bed.
I guess I'll have to go back to exactly what statements you're relying on for this instruction.
I'm relying on the statements that the court allowed to be admissible as admissions on the part of the defendant. And that is those admissions in the Bashir video. And I think I provided the court with a copy of what I believe to be consistent with the court's ruling earlier before the trial started, and I believe those statements apply. I think the problem here is that, an admission is something from which the jury draws an inference. Whereas a confession would be a completed statement as to all elements of the crime. And the reason that the court ruled that those admissions were to come before the jury is because it does indicate that he has a motive and intent to sleep with young teenage boys, and he has admitted to doing so, which allows the jury to draw an inference that he did so with Gavin under circumstances which are directly related to the crimes alleged in this count.
Actually, I'm looking at what was submitted this morning by the prosecution, and it's a document that doesn't have anybody's name on it. And I think Your Honor asked your clerk to check. That's the one that was filed by the prosecution and…
Yes, I have it.
I'm just looking at it now, again having received it this morning. I'm certain these are not the correct excerpts.
Well,
the correct excerpts, meaning what?
Well, Your Honor ruled earlier that certain statements could come in if they laid the foundation and got the tape in, and they introduced the Bashir tape that had some statements. They also sought to introduce another tape that never came into evidence. But, for instance, page 2 here, it says, on page 41, there's a discussion between Gavin and Bashir. I just look at that, and I know that wasn't one of the parts that the court approved. We could go back and figure it out, but aside from that, the general proposition is that what they wanted to introduce were statements of Michael Jackson that could be construed as
admissions.
Admissions that of course would have to be admissions as to prior conduct, not future conduct, because there's no future conduct yet by definition. That would come in under 2.71. We are proposing in a special instruction that the court not delineate the exact paragraphs, and instead, with both the Bashir tape and the outtakes, the court categorize it as statements by Michael Jackson that pertain to his relationship with children.
I know that, but I can't see you getting anywhere with that one, so.
Oh, you can't. Well, it just seemed to be an easier way to do it. But the point of the story is, whether we do it that way or not, that's what it was about. The court was ruling that statements.
But what I had ruled was that certain statements, if the jury determined that they were admissions, could be used for the truth of the matter asserted. And I asked Mr. Sneddon to give me a list of the statements that he thought he would be relying on to submit to them for admissions. And the purpose of that was that I needed to know what statements I might allow you to put in for the truth of the matter asserted which were connected to the admissions and not generally connected to everything he said about children.
Okay.
Which is what you threw in your instruction. So let's take a break.